Okay, picture this. The sparkling water, the hum of luxury engines. You found the perfect yacht. You make an offer, pay a deposit, and then, well, life happens. Just days later, you need to back out. Seems like it could be a simple cancellation, right?
You'd think so. Buyer changes mind, maybe the seller keeps the deposit.
Exactly. But what if the item is worth, say, over $1 million, and the seller comes back and says, nope, sorry, you bought it. Suddenly, that simple change of heart can spiral into, well, a multi-year legal battle.
Absolutely. And this isn't just some hypothetical. We're talking about a fascinating and actually quite dramatic deep dive into contract law, what happens when a big deal goes sour, and the often pretty brutal reality of fighting it out in court.
Yeah, this particular saga went all the way to the highest court in New South Wales.
It did.
And that's exactly where we're heading today. We're diving into the court case of Cheng v. Motor Yacht Sales, Australia. It's a story that starts with, a dreamboat, a beautiful 48-foot Princess yacht.
Sounds lovely.
But it evolves into this really complex legal dispute. And it teaches us some powerful lessons about when a deal is actually binding, how you figure out loss when things go wrong, and, maybe most importantly, the eye-watering costs of litigation.
And our guides for this deep dive aren't just us talking. We've got the official court judgments themselves, the rulings from the Supreme Court of New South Wales, and then the NSW Court of Appeal.
Right.
They lay out the whole story, the procedural journey, the evidence, the arguments, all the names, the parties, the lawyers, the judges, and, of course, the final decisions.
So our mission today is to unpack this whole drama step by step. We'll follow it right from that initial offer.
Yeah.
Through the first big court battle, the judge's crucial decision, a little post-judgment twist you might find interesting.
Oh.
And then the high-stakes push for an appeal. We'll introduce you to the key players involved, the solicitors, the barristers, and really dig into the legal fights along the way. So yeah, get ready for a deep dive into contracts, damages, and the surprising truth about legal costs.
Okay, let's get into it. Starting with the star of the show initially, the yacht itself.
Right. We're talking about a 48-foot Princess Open Sports Yacht V48 601. Bit of a mouthful, but sounds pretty impressive, doesn't it?
Definitely. High-end, high-value asset, no question.
And the potential buyer was Mrs. Jian Ling Cheng. Now, you'll see her name pop up in the court documents variously as the applicant, the defendant, or the cross-claimant, depending on which court and what stage we're talking about.
Standard stuff in litigation.
She made an offer to buy this V48 from Motor Yacht Sales Australia, Peter LVPD, and they trade as the Boutique Boat Company. Let's just call them MYSA for short.
Okay, MYSA. They're the respondent or plaintiff or cross-defendant.
Got it. So Ms. Cheng puts in her offer, $1,180,000.
Wow. Big number.
That was on October 1st, 2016. And on that exact same day, she paid a $20,000 deposit. Seems like a solid start. Things are moving.
It definitely looked that way. But then the dispute ignites really, really quickly. Just 4 days later, October 5th, 2016.
Uh-oh.
Ms. Cheng tries to withdraw her offer.
The attempted escape clause. Something must have shifted for her. So less than a week after making the offer and paying the deposit, she tries to cancel.
Precisely. But MYSA, they dug their heels in. Their position was absolutely firm.
What did they say?
They claimed that by October 5th, the offer had already been accepted. So from their point of view, a binding contract was already formed.
Meaning her withdrawal was just too late. It had no legal effect.
That was their argument. Too late. The deal was done.
Okay, so boom. The central conflict is immediately clear. Was there a legally binding contract before Mrs. Cheng tried to pull out on October 5th? That timing becomes the absolute core battleground, doesn't it?
It really does. That's the first major hurdle in the case.
And because Mr. Cheng was saying, no, I'm out, and refused to proceed, MISA had to figure out what to do with this $1 million yacht.
Right. They had to take action to manage their situation. Their response was basically to try and mitigate their potential loss, which meant selling the V48 to someone else.
Which is the standard, sensible thing to do in that spot, right? You can't just let it sit there gathering dust and costing money.
No, exactly. So back on the market it went.
Did they find another buyer?
Yes. They managed to sell the V48 in January 2017.
Okay, and here's where it gets really, really interesting. What did they sell it for?
They sold it for $1,200,000. Hang on,
$1,200,000?
Yep.
But Miss Cheng's original offer was $1,180,000. That's $20,000 more.
Correct. Now, there's a slight complexity. The resale wasn't just straight cash. It involved $600,000 in cash and a trade-in vessel, another boat, a V39, which was valued at $600,000 for the purpose of that deal.
Okay. A part exchange kind of thing.
Exactly.
Yeah.
But the stated headline price for the V48 itself in that resale deal was $1.2 million, higher than Cheng's offer.
You'd think, okay, great, they sold it for more, no harm done, maybe even a small profit.
Yeah.
Solve.
That's what you might think. But NYSA didn't see it that way at all.
No, even though they got a higher price.
Nope. Despite the higher resale price, NYSA claimed they'd actually suffered significant losses because Ms. Cheng failed to complete the original contract.
Okay, I need to understand this. How can you lose money when you sell something for more than the first buyer offered?
Well, that's exactly what the court case was about. This is where the formal legal battle kicks off. NYSA sued Mrs. Cheng for damages.
Right, so they took her to court.
They did. The lawsuit landed in the Common Law Division of the Supreme Court of New South Wales. And we even have the file number, 21-835-6960.
Okay, let's pause and introduce the legal teams for this first round in the Supreme Court. It's always interesting to see who's arguing the case.
Absolutely. So for NYSA, the plaintiff trying to recover damages, their solicitors were a firm called Pure Legal.
Pure Legal, okay.
And their barrister, the counsel arguing in court, was M. Hall.
Got it. And on the other side, for Mrs. Cheng, the defendant trying to resist the claim and also a cross-claimant for her deposit back.
Her solicitors were Luminous Legal.
Luminous Legal.
And her barrister was J. Mitchell.
Okay, so Pure Legal and M. Hall for NYSA, Luminous Legal, and J. Mitchell for Mrs. Cheng. And who was the judge hearing all this?
The primary judge, the one presiding over the Supreme Court trial and making the first big decision, was Justice Payne, or Payne J.A., as he's referred to in the judgment. He sits on the Court of Appeal now, but was hearing this case then.
Right. So the stage is set. We've got the parties, the lawyers, the judge. How long did this trial actually take?
It was quite substantial. A 4-day hearing. It took place over 24th to 26th May, and then finished up on 28th May, 2021.
4 days in court. What were the main arguments they were thrashing out?
Well, it really boiled down to those two crucial points we sort of touched on earlier.
Okay, first up must be that contract formation issue, what judgments called the authority issue.
Exactly. Was the offer definitively accepted before Ms. Cheng tried to withdraw on October 5th? And a really key part of that was, did NYSA's own people, specifically their general manager for sales, Mr. Hugh Simpson, and the company's secretary, Mr. Jim Thompson, did they actually have the necessary implied authority to accept Ms. Cheng's offer on behalf of the company, NYSA, and therefore create a binding deal?
Right, because it's one thing for someone to say yes. It's another for them to have the legal power to bind the company they work for, especially on a $1 million deal. Was that contested?
Oh, yes, very much so. That question of who could legally bind the company was absolutely central. There's also a secondary argument from Ms. Cheng at the trial, something about whether the contract required the boat to fit in her specific mooring.
Of a practical issue.
Yeah, but the judge, Payne J.A., ultimately rejected her evidence on that particular point. So the main fight stayed on authority and damages.
Okay, so the second big issue then was damages. The damages issue. If there was a contract, what losses could NYSA actually claim?
Right. Could they recover all those expenses they presumably incurred while holding onto the boat after Ms. Cheng backed out? You know, things like berthing fees, maybe some advertising, maintenance, detailing, fuel for moving it, insurance.
Yeah, all the costs of just keeping and trying to resell a massive yacht.
Exactly. And the really big controversial question, could they claim the brokerage fees they paid on the resale of the V48?
Even though they sold it for more than Ms. Cheng's price? That does seem like the sticking point.
It really does. It feels counterintuitive, doesn't it? How can that be a loss?
Yeah. So the court heard evidence over these 4 days.
Yes. Evidence from Ms. Cheng and also from Mr. Cheng Shu, although the judgment notes their evidence on the core liability issues wasn't accepted by the judge.
Okay.
And crucially, evidence from NYSA's side. Mr. Hugh Simpson and Mr. Jim Thompson, the very people whose authority was under scrutiny.
Right. Their evidence would have been vital on that point. So after these 4 days of argument, evidence, legal submissions from Mr. Hall and Mr. Mitchell, Payne J.A. had to make a decision.
He did. He delivered his judgment on 10 September 2021, and the formal citation for that is 2021 NSWSC 1141.
Okay, so the big question first. Contract or no contract? What did he find?
He found for NYSA, he concluded that, yes, a binding contract was formed before Mrs. Cheng tried to withdraw on October 5th.
When?
He found it was formed either orally on October 1st, the day of the offer, through the actions of Mr. Simpson, the sales manager.
Okay.
Payne JA found that Mr. Simpson did have implied authority based on his role in the circumstances. Or, the judge said, at the very latest, the contract was formed by written execution on October 2nd by Mr. Thompson, the company's secretary.
Right.
And he also found Mr. Thompson had the necessary implied authority. So, one way or another, the deal was done before the 5th.
And he explicitly addressed the evidence from Mrs. Cheng and Mr. Cheng's shoe.
Yes, he explicitly rejected their evidence on those central liability points regarding contract formation.
Wow. So on the main battleground, was there a deal? Mrs. Cheng lost. The court found she had breached a binding contract by trying to back out too late.
Correct. That hurdle was cleared in MYSA's favor, which then brings us to the second big question, damages.
How much did Mrs. Cheng owe? What did Payne JA decide MYSA could recover?
He accepted MYSA's claim for the reasonable expenses they incurred specifically because of the breach, incurred while they were mitigating their loss by holding on to the yacht and reselling it up until that resale happened in January 2017.
Okay, what specific costs did he allow? Did he list them?
Yes, the judgment lists them out. He allowed costs for berthing the yacht that was $19,550, a small amount for advertising, $85, maintenance and repair costs of $3,809, detailing the boat, $12,000.
Pricey business detailing a yacht like that.
Apparently so. Also, skipper fees, fuel, transport costs $778, and insurance for the period, $2,888.
Okay, if you add those up, it's roughly $39,000 or so. Those seem like direct costs of holding the asset.
Correct. Those totaled $39,120. They seem pretty directly linked to the situation, but then came the big one.
The brokerage fee on the resale, did he allow it?
He did. He allowed the brokerage fee that MYSA paid when they resold the V48 to the new buyer. That fee came to $63,600.
Wow, $63,600. How was that calculated?
It was calculated as 5.3% of the $1,200,000 resale price.
Okay, so that single commission fee is actually more than all those other holding costs put together.
It is. Significantly more. So the total allowed expenses, the holding costs, plus that brokerage fee added up to $102,720.
$102,720 in expenses MYSA could claim. But wait, they still sold it for $20,000 more than Miss Cheng's offer? How did that factor into the final number?
Right. This is where the calculation gets crucial. And it shows how damages work in these breach of contract cases. Even though they sold it for more, the judge first calculated the total reasonable expenses incurred because of the breach, which was that $102,720.
Okay.
Then from that total expense figure, he deducted the profit MYSA made on the resale, that $20,000 difference between Ms. Cheng's original offer price and the final resale price.
Okay. So the gain gets offset against the costs. That makes sense.
Exactly. And he also deducted the $20,000 deposit that Ms. Cheng had already paid and MYSA had held on to.
Right. She doesn't pay that twice. So let's do the math. $102,720 in allowed expenses, minus the $20,000 resale profit, minus the $20,000 deposit already paid.
That calculation leads to a final damages award of $62,720.
$62,720. That's the amount Ms. Cheng was ordered to pay MYSA in damages?
Precisely, but that wasn't all.
More.
Yes. In addition to the damages, she was ordered to pay MYSA's legal costs. Initially, the order said costs of the trial, meaning their lawyers' fees and expenses just for those 4 days in court.
Which would still be substantial, I imagine.
Oh, absolutely. And she also had to pay prejudgment interest on the $62,720 damages amount calculated from January 10th, 2017, around the resale date, up to the judgment date in September 2021.
Okay. And what about her own cross-claim? Was she trying to get her deposit back?
Yes. She had a cross-claim against MYSA, presumably for the return of the deposit. That was dismissed. And she was ordered to pay MYSA's costs for defending that cross-claim, too.
So a pretty comprehensive loss for Ms. Cheng at the first instance. Found liable for damages, interest, and MYSA's trial costs, plus her own claim failed. You'd think that might be the end of a very expensive road.
You might think so. But no, there was a little postscript. A fascinating and actually legally quite significant post-judgment hiccup.
Go on. What happened after the judgment?
Well, very shortly after the decision, on October 2nd, 2021, MYSA's solicitors, Pure Legal, contacted the court again.
Pure Legal again. What was the issue this time?
They weren't happy with the wording of the costs order. Remember, the judge had ordered Mrs. Cheng to pay MYSA's costs of the trial.
Right. The cost for the 4 days.
Pure Legal argued this was actually an accidental error. They believed the judge's clear intention, based on the overall judgment, was for Mrs. Cheng to pay the costs of the entire proceedings, not just the 4 days of the hearing itself.
And the cost of the whole case would be much, much higher than just the trial days, wouldn't they? All the prep, filings, interim steps.
Dramatically higher. Years of work, potentially. So Pure Legal asked the court to correct this order under something called the slip rule.
The slip rule? What's that? Sounds like fixing a typo.
It's kind of like that, but for court orders. It's Rule 36.17 of the Uniform Civil Procedure Rules in NSW. It basically allows a court to correct accidental mistakes, slips, or omissions in its own judgments or orders to make sure the record reflects the court's actual intention.
Okay.
Pure Legal argued that the phrase costs of the trial was just such a slip, and it was tolerably clear from reading the judgment as a whole that Payne JA had intended to award costs for the entire case.
Okay, so MYSA pushes for potentially much larger costs recovery. What did Mrs. Cheng's side say? Her solicitors were luminous legal.
Well, interestingly, Luminous Legal responded by saying they had no position on this proposed change. They essentially left it entirely up to the judge to
I
decide.
think this is non-committal.
Yeah.
So what did Payne JA do? Did he agree it was a slip?
He did. On October 8th, 2021, he issued a further short judgment. The reference is 2021 NSWSE 1281.
Okay.
He agreed with MYSA's lawyers. He stated that his intention was tolerably clear from the original reasons he had met costs of the entire proceedings, covering everything from start to finish, not just the trial days.
So he used the slip rule.
Yes. Applying the slip rule, he formally varied his original order. He changed the wording from costs of the trial to costs of the proceedings.
Wow. And that single word change, trial to proceedings, could potentially mean tens, maybe even hundreds of thousands of dollars difference in the final costs bill Ms. Cheng would face.
Absolutely. It's a huge difference in scope. The financial implications of that correction were massive.
Okay. So perhaps unsurprisingly, facing damages, interest, and now the potentially vast costs of the entire proceedings, Ms. Cheng wasn't ready to give up.
No, the fight wasn't over yet. She decided to challenge the outcome.
How? Where do you go from the Supreme Court?
You seek permission, or leave, as it's formally called, to appeal the decision to the next level up. The Supreme Court of New South Wales Court of Appeal.
Okay, escalating it. Do we have a file number for that?
We do. The Court of Appeal application number was 2012-85420.
And who heard this application? The judges in the Court of Appeal are usually very senior.
Yes, it was a very senior bench indeed hearing this leave application on 28 June 2022. It comprised Chief Justice Bell CJ, Justice Ward, who is the president of the Court of Appeal, Ward P., and Acting Justice of Appeal Baston AJA.
A heavyweight panel. And what about the legal teams? Did the same lawyers run the appeal arguments?
Mostly. For Ms. Cheng, the applicant seeking leave to appeal, she stuck with her original team. Her solicitors were still Luminous Legal, and her barrister arguing the appeal was Mr. J. Mitchell, the same counsel who ran the trial for her.
Okay, continuity there. What about MYSA, the respondent defending the original judgment?
They also stayed with Pure Legal as their solicitors. However, their barrister for the appeal was different. It was Ms. Elrich.
Ms. Elrich for MYSA this time. Is it common to change counsel for an appeal?
It's not uncommon, yeah. Sometimes it's due to availability. Sometimes a party might want someone with specific appellate advocacy experience or just a fresh perspective. So, new counsel for MYSA at this stage.
Now, you mentioned seeking leave to appeal. That implies it's not an automatic right to have your appeal heard in this situation. Why did Ms. Cheng need permission?
That's a really important point about how the court system manages its workload and resources. It comes down to the amount of money involved.
This $62,720 in damages.
Exactly. Because that amount awarded at the trial was less than $100,000, a specific rule kicks in. It's Section 101(2) of the Supreme Court Act 1970 in NSW.
What does that section say?
It basically says that if the amount in dispute in the appeal is under $100,000, you don't get an appeal automatically. You have to apply for, and be granted, permission leave from the Court of Appeal itself before the full appeal can proceed.
So it's like a gatekeeping function.
Yeah.
The Court of Appeal gets to decide if the case is worth their time, especially for smaller monetary claims.
Precisely. It prevents the highest court being swamped with appeals over relatively small sums.
What does someone like Mr. Cheng need to show to convince those three senior judges to grant that permission? What's the test for getting leave?
The bar is set quite high. It's not enough just to say you think the first judge got it wrong. The applicant, Ms. Cheng here, has to demonstrate something more significant.
Like what?
Typically, you need to show that the appeal involves an issue of legal principle, or perhaps a question of general public importance that needs clarification. Or you need to show that there's been a reasonably clear injustice, something more than just an arguable point of disagreement with the first judge's decision.
So not just I might have won if argued differently, but something fundamentally wrong or significant.
Exactly. The Court of Appeal actually cited some previous cases in their judgment, like J. Carr v. Lombardo and B. Financial v. Days, which set out these strict criteria. They're there to make sure the Court of Appeal's resources are focused on cases that genuinely warrant their attention, cases that might set important precedents or correct clear errors of principle.
Okay, so Ms. Cheng, through her counsel, Mr. Mitchell, had to convince Bell CJ, Ward P, and Baston AJA that her case met this high bar. What were her main arguments for why leave should be granted? Did she raise the same issues?
Pretty much, yes. She essentially reran her two main arguments from the trial, framing them now as reasons why the primary judge's decision was wrong enough to warrant an appeal.
So ground one would be the authority issue again.
Correct. She argued that Payne J.A. was wrong to find a binding contract had been formed before her withdrawal attempt. She specifically challenged his findings on the implied authority of Mr. Simpson and Mr. Thompson, suggesting those findings weren't properly open to him based on the way the case was pleaded or the evidence presented.
Okay, challenging the factual finding on authority. And ground two, that must be the damages issue.
Yes, specifically focusing on that controversial brokerage fee paid on the resale.
The $63,600.
That's the one. Mrs. Cheng argued, again, that allowing MYSA to recover that brokerage fee was legally wrong because MYSA had ended up selling the boat for more than her original offer price. Her core argument was that awarding this fee resulted in an unjustified windfall gain for MYSA. They shouldn't get damages and sell for more.
Right, the double-dipping kind of argument. Seems like a reasonable point to argue, at least on the surface.
It certainly had a logical appeal. So those were the two main planks of her application for leave, argued by Mr. Mitchell and responded to by Mrs. Rich for MYSA. The Court of Appeal had to decide. Did these arguments raise an issue of principle or show a clear injustice sufficient to grant leave?
And what was the outcome? Did they get leave?
No, they didn't. The decision was delivered on 6 July 2022. The citation is 2022 NSWCA 118, and the Court of Appeal dismissed Mrs. Cheng's application for leave to appeal.
Refused permission. So the original decision stands. Let's break down why they refused. What did they say about the authority issue?
On the authority issue, whether Simpson and Thompson had implied authority, the Court of Appeal basically said the primary judge's findings were fine. They found his conclusions were well supported by the evidence that came out during that 4-day trial.
So they deferred to the trial judge's assessment of the facts.
Largely, yes. They also specifically noted that Mrs. Cheng's team hadn't actually complained during the trial that the judge's findings on authority went beyond what MYSA had pleaded in their case, or that it caused any unfair surprise or prejudice to her.
You need to raise those objections at the time.
Generally, yes. So the Court of Appeal concluded this wasn't really an issue of legal principle. It was essentially just Mrs. Cheng disagreeing with the primary judge's evaluation of the facts and evidence. And that's usually not a strong enough basis to get leave to appeal.
Okay, so no joy on the authority argument. What about the damages issue? The brokerage fee and that windfall gain argument. That felt like maybe her stronger point.
The Court of Appeal addressed that directly, and Mrs. Rich, the counsel for MYSA, seems to have made a crucial point from the original trial evidence.
What was that?
She pointed to evidence given by Mr. Thompson at the trial, evidence that Mrs. Cheng's team hadn't challenged at the time, showing that brokerage fees would not actually have been payable by MYSA on the original sale to Mrs. Cheng.
Really? Why not?
Apparently, there was some sort of specific discount or arrangement in that original deal, meaning MYSA wouldn't have had to pay brokerage if Mrs. Cheng had completed the purchase.
That changes everything, doesn't it?
It's a game changer for that argument, because if they wouldn't have paid brokerage on the original deal,
then having to pay it on the resale becomes a genuine new expense that only arose because she breached the contract. It's not double dipping. It's a direct cost of mitigation.
Exactly. The Court of Appeal agreed. They found that the brokerage fee paid on the resale was a genuine, reasonable expense incurred by MYSA in mitigating the loss caused by Mrs. Cheng's failure to complete. It was recoverable under established legal principles about mitigation costs.
Do they mention any specific legal authority for that?
Yes, they cited longstanding principles, referencing cases like the High Court's decision in Fox v. Wood, which basically confirms that an innocent party who suffers loss from a breach of contract is entitled to recover the reasonable expenses they incur trying to reduce or mitigate that loss.
So again, the Court of Appeal saw this not as some novel issue of principle, but just the correct application of settled law to the specific facts found by the trial judge, particularly that fact about brokerage not being due on the original deal.
Precisely. Not an issue of principle, no clear injustice demonstrated on that ground either.
So neither of Mrs. Cheng's specific legal arguments managed to clear that high threshold for getting leave to appeal.
That's right. But the Court of Appeal didn't stop there. They highlighted another, even broader, overriding factor in their decision to refuse leave. And this, I think, is maybe the most significant takeaway from the appeal stage.
What was that?
It was the principle of proportionality.
Proportionality, you mean like the cost of fighting versus what's actually at stake?
Exactly that. They put significant emphasis on this. They directly referenced that Section 1012 of the Supreme Court Act, the rule setting the $100,000 threshold we talked about. And they also pointed to Section 60 of the Civil Procedure Act 2005 and NS Value. That's a section that basically tells courts they have a duty to manage legal proceedings in a way that is just, quick, and cheap, or more accurately, with costs that are proportionate to the importance and complexity of the issues in dispute.
So the law explicitly tells courts to consider if the legal costs are getting out of whack with the actual dispute.
Yes. The Court of Appeal quoted some earlier cases that explained the whole purpose of having that monetary threshold for appeals. It's there to achieve finality for smaller claims, to stop litigation being driven just by the potential to recover huge legal costs, and importantly, to make sure the court's limited time and resources are used efficiently.
And did they look at the costs in this specific case?
They did, and this is where it gets really stark. They explicitly noted that the legal costs just for the 4-day trial back in the Supreme Court likely approached, or maybe even exceeded, the actual amount of damages awarded, that $62,720.
Wow, the costs of the trial alone might have been more than the amount they were fighting over.
That's what the Court of Appeal observed. And their statement on this was pretty direct. They said that this kind of litigation where the costs incurred are clearly disproportionate to the amount in issue is a poor candidate for a grant of leave, unless those general criteria for leave, like a clear issue of principle or public importance, are strongly met.
Which they found weren't met here.
Correct. So that proportionality factor weighed heavily against granting leave. It's a really clear message from the court. Just because you can fight doesn't mean the system will let you keep fighting indefinitely, especially when the costs dwarf the prize.
That is a stark message. The legal costs themselves very quickly became the dominant figure in this whole dispute, financially speaking.
It really highlights the potential financial reality of litigation, doesn't it? So, putting it all together, the Court of Appeal concluded that Ms. Cheng had failed. She hadn't identified any issue of principle, no question of public importance, no reasonably clear injustice that went beyond just disagreeing with the trial judge's view of the evidence.
And combined with the disproportionate costs involved.
Combined with the proportionality issue, the outcome was clear. Leave had to be refused.
So the final act of this particular legal drama, the application for leave to appeal, is dismissed.
That was the end of the road for this specific legal battle. The Court of Appeal refused permission for a full appeal to be heard.
And costs. Usually the loser pays.
Yes. Adding insult to injury, really. Mrs. Cheng was ordered to pay MYSA's legal costs for this unsuccessful appeal application as well.
So her total bill just kept climbing.
It did.
And was this decision unanimous among the three judges?
Yeah.
Bell CJ, Ward P., and Baston AJA.
Yes, the judgment indicates it was a unanimous decision. All three agreed leave should be refused.
Okay, so let's step back. We followed this journey from a handshake well, an offer and deposit on a luxury yacht, through a breakdown, a lawsuit, a 4-day trial with specific lawyers, Pure Legal M. Hall versus Luminous Legal J. Mitchell, before a specific judge, Payne J.A.,
Right.
then a slip rule correction on costs, and finally an unsuccessful attempt to get leave to appeal involving different counsel, as is Elrich for MYSA, before 3 very senior judges, Bell C.J., Ward P., Baston AJA. What does this whole saga actually mean for you, our listener? What are the big takeaways?
Well, I think there's some really critical takeaways here, relevant to anyone entering into any kind of significant agreement, really.
Okay, like what?
First, obviously, contract formation. Understand exactly when your deal becomes legally binding. It's not always crystal clear.
Yeah, that finding on implied authority for MYSA's managers, Mr. Simpson and Mr. Thompson, that's important, isn't it? It wasn't just about one specific signature. It was about their roles and actions.
Absolutely. That idea that someone can bind a company based on their position and what they normally do, their implied authority, is huge in business deals. You need to know who you're dealing with and if they actually have the power to make the deal stick.
Good point. What's the second takeaway?
Damages. The case gives us a really clear picture of how damages are calculated when a buyer defaults on, say, a purchase like this. Crucially, even if the seller manages to resell the item for a higher price,
Yeah.
they can still potentially recover the reasonable costs they incurred specifically to mitigate their loss, provided those are costs they wouldn't have had to pay if the original deal had gone through.
That brokerage fee is the perfect and perhaps surprising example of that principle in action, because they wouldn't have paid it on the Cheng deal, but had to pay it on the resale.
Exactly. It directly flowed from the breach.
Okay. And the third takeaway. This feels like the big one from the appeal.
Yeah, I think it is. It's the stark, brutal reality of legal costs versus the amount you're actually fighting over. That proportionality principle the Court of Appeal hammered home.
Right. It's a real aha moment, isn't it? The legal system isn't just a free-for-all where you can pursue any claim regardless of cost.
No. There's this constant balancing act going on between providing access to justice and ensuring the system remains efficient and doesn't get clogged up with disputes where the costs are just completely disproportionate to what's at stake.
So your right to appeal, especially for smaller amounts under that $100,000 threshold, isn't absolute. It's constrained by this idea of proportionality.
Very much so.
So for anyone listening, think about any significant agreement or deal you make. Understanding when it clicks over into being legally binding is step one. But step two, if a dispute does arise, this case is just such a powerful reminder to take a deep breath, step back, and seriously consider the potential costs, your costs, their costs of pursuing or defending a legal claim.
Yeah. Compare those potential costs to the actual amount of money or value you're realistically fighting for. Because, as this case shows,
The cost of the fight itself can very easily become the biggest number in the equation, the biggest loss, potentially.
it really can.
So we've navigated the chalky waters of contract formation, implied authority, mitigation of damages, resale profits, slip rules, and the high bar for appealing smaller claims, all stemming from one luxury yacht deal that just completely fell apart.
It's quite a journey through the legal process.
And the final outcome is crystal clear. Mrs. Cheng was held to the contract. She was found responsible for the damages, the interest, and MYSA's legal costs through 2 levels of the NSW court system.
With that final refusal from the Court of Appeal really emphasizing the disproportionate nature of the costs involved relative to the initial damages award.
And that leaves us with, I think, a really provocative thought to consider long after this deep dive ends. This case is such a powerful reminder that in the world of litigation, sometimes the most significant figure isn't the actual damages awarded, which was $62,720 here.
Pocket change compared to the likely legal spend.
Exactly. The truly staggering figure is often the total cost incurred by both sides simply to fight the battle. Hiring the solicitors, Pure Legal, Luminous Legal, briefing the barristers, M. Hall, J. Mitchell, M. Rich, court fees, expert reports maybe. When you tally all that up across years and multiple court levels, it likely ran into the hundreds of thousands of dollars.
Easily.
So, when you're facing a potential legal battle, maybe the very first and most critical question you should ask yourself isn't just, am I right, but are the potential costs of proving I'm right truly proportionate to what I realistically stand to gain or lose?
A question that could save a lot of time, money, and heartache.